All right, the meeting of the General Laws and Technology Committee will come to order now. We'll call the roll.
Mr. Chair, you have a quorum.
All right, we have a quorum. We got several bills to try to wrap up our docket for the year in General Laws and Technology Committee here. I handled a large number of bills from both the Senate and the House on these things. We have a recess, at least on the Senate side, till 4 o'clock, and so we'll try to get everything done by then. And I may have to go to another meeting, but we'll keep going here. So, all right. So I will call, and what we're going to do is we can't get much public testimony, so let no more than 2 minutes on either side for any public testimony on anything. We'll start out with Delegate Head. So,
thank you, Mr. Chairman. We have House Bill 1289. This is a very simple bill. It's a Section 1 bill that simply directs the Board of Housing and Community Development to consider during their next development cycle revising the Uniform Statewide Building Code to offer some exemptions for energy standards, specifically for Section 306, the factory group, Section 311, the storage group S, and Section 312, utility and miscellaneous group U. These are areas, right now, the requirement is that they have to be fully insulated when they're built. A good example of this would be an airplane hangar. It adds for us about 15% minimally to the cost of building if we have to do this, but it doesn't make any sense to have to insulate a building that's going to have the door standing wide open 60% of the time. Likewise, if you've got a warehouse that's being built that doesn't need to be climate controlled, there's no need to mandate that it has HVAC systems in it if it's never going to be turned on, because there's no reason to go to the expense of doing that. And so we are currently at a competitive disadvantage to North Carolina for some economic development. That's why we brought the bill. It doesn't mandate anything. We're not trying to change the code through legislation, just simply trying to ask them to take a look at this and consider in the next round giving us the same leverage that we have in other states.
all right. Are there any questions of the patron? All right. Is there? What I'll do today is sort of try to take opposition first, and if you don't get a whole lot of opposition, then you don't have to have a whole lot of people speak in favor of it. So anybody want to speak in opposition to the bill?
If you're in the Zoom room and wish to speak in opposition to this bill, please raise your hand electronically now. Mr. Chairman, there are no virtual speakers.
All right. There's a motion. Is there a second? All right, we got a motion and a second to report the bill. If there's no further discussion, we will vote on the board.
Ayes 6, noes 7.
All right, ayes 6, no 7.
Okay.
Good try.
Well, thank you, Senator.
All right, next we have Delegate Les Adams. So. Delegate Adams here. All right, Delegate Campbell. Okay. Delegate Price. Moving along.
I see you. I see you. I can see you.
I'm pretty sure you can see me today.
You got George going without me?
I did.
How's that even possible? Usually it takes a taser.
I've seen you run. You can run
Usually it
fast.
takes a taser.
Yes.
Mr. Chair. Mr. Chair.
Yes.
Having voted on the prevailing side of the most recent bill that we passed, House Bill 1289, can we please vote again for a member who was not here? Reconsider the vote.
Okay. You want to reconsider? All right.
Was that, was she on the prevailing side? Okay.
Yeah. Yeah. All right. Yeah. She did. She did. She left a proxy, yeah. All right. There's a motion and a second to reconsider the vote on 1289. Let's vote on the board.
Ayes 15, no zero.
All right. We are back to the action on 1289. All right, we got a motion and a second to report. All right, all in favor say aye, or vote aye, and those opposed no.
Ayes 9, no 6.
All right, ayes 9, no 6. All right, that, you worked your magic. As long as you weren't here, that we did fine, so, but.
I'll stay away.
All right, Delegate Campbell. Delegate Campbell, right here, okay. Delegate Price, where were we? Okay.
Thank you, Mr. Chairman and members, senators. So as we are still in the beginning stages of name, image, and likeness contracts, we just want to make sure that we provide time for the General Assembly to put the same time, effort, and consideration into the guardrails and protections for student athletes in high school as we are doing that great work for those that are in college. And so that's what House Bill 1298 would allow for us to have that time to come back and do that.
All right, are there any questions of the patron?
So, Mr. Chairman,
Yes.
I have heard some feedback let me give you a potential situation. So sorry. That if there were, let's say, a football player that had a YouTube channel for growing plants or pets, that this was only supposed to be for the activities related to sports and not for other activities that they may have going on. And so I hear that feedback, and I would accept a friendly amendment to that nature.
All right. Is there anyone who wants to make a friendly amendment?
Yeah, Mr. Chair, maybe if council can help us to make sure that this is narrowed down and is solely related to the sports activity in question and not other ancillary income that the individual might have. I'd like to offer the amendment once council can maybe clarify for us.
Thank you, Mr. Chairman. We could put together that friendly amendment. Would probably just add some language on line 12 so that it would read, shall enter into any contract to receive compensation in relation to such students' athletic participation.
Mr. Chair, I'd so move.
All right, is there a second to that amendment? All right, any discussion on the amendment? All right, all in favor of adopting the amendment, please say aye.
Aye.
All opposed, no. All right, that amendment's adopted. Is there anyone who wants to speak in opposition to this bill?
If you are in the Zoom room and wish to speak in opposition to this bill, please raise your hand electronically now. Mr. Chairman, there are no virtual speakers.
All right, we got a motion and a second to report the bill. If there's no further discussion, we'll vote on the board.
Ayes 15, no 0.
All right, ayes 15, no 0.
Thank you, senators.
All right, Delegate Rome.
Thank you, Mr. Chairman. Thank you to members of the committee. I have two bills here. We'll start with HB 615. And both of these bills affect the joint area represented by Senator Stewart and I. This is basically about the the community of Thoroughfare. But what we're trying to do is basically learn some really tragic mistakes that happened in the last year that led to a cemetery, a historic African American, Native American cemetery being bulldozed over. And so one of the things that came up is that when we're dealing with a lot of heirs properties, that when these properties end up going to a county because either of a lack of an heir or because of insufficient tax payments, that they are then basically put up for auction. And very oftentimes the families are not aware that the burial sites where their ancestors are buried are actually going out, are up for sale in the first place. So this first bill, HB 615, this will basically allow, this will make sure that localities are able to notify, or doing the outreach to notify those next of kin in the first place, to let them know that the sale is about to happen. We worked out details with VACO and VML on the House side with this, and we also have someone to testify in favor of the bill online today.
Okay. All right, are there any questions of the patron? All right, is there anybody in opposition to the bill?
If you are in the Zoom room and wish to speak in opposition to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers in opposition.
All right.
Second.
All right, we got a motion and a second to report. If there's no further discussion, we'll vote on the board.
Ayes 13, no zero, 2 abstentions.
All right. Thank you. That motion is passed, so this bill is reported. Do you have another bill?
Yes, sir, Mr. Chairman. Thank you very kindly. For this next one, the heart and soul of this is basically in line 22, where it says the governing body shall publish a notice in a newspaper having journal circulation in the locality at least 2 weeks prior to the public sale of any publicly owned property that contains a cemetery or soon thereafter as possible, and shall also publish the notice on the locality's website if one exists. The whole point of this is to make sure that when a property that is going up for sale that is currently owned by a locality actually happens, that people know they are actually purchasing a piece of land that has a cemetery on it. And they are already required to publish these public notices in the first place. This just makes sure that we're adding one line, so there's no additional fiscal impact to the state or to the localities on it, because they are already required to do that. And the first section on this regarding the registry and map part, all of that is permissive, and we also worked that out with a Native American organization to make sure that there were some guardrails in place, because there's what's basically referred to as Indian grave robbing, and we wanted to make sure that we were protecting those cemeteries in a for issues that are very unique to that community, while at the same time keeping the heart and soul of the rest of the bill intact.
All right. Are there any questions of the patron?
Mr. Chairman, a quick question.
Yes, Senator Bell.
Thank you. My question is, reading the bill, I mean, I like where the bill's going. The only question I've got is, is there any provisions if you sell a property and you didn't know that there was a burial ground on your property? Is there any protection in that case?
Sure. So, Mr. Chair, what I would say to the delegate on this case is that this is basically going to be for those that are going up to sale that are publicly owned. So this is from the locality in this case, beginning on July 1st of this year. And so, because that's not going to directly affect the private seller in that case, or the private property owner in that case, it's going to be coming from the locality. The answer would be no. There's not that concern.
Mr. Chairman.
Yes, Senator Bell.
Would you be open to what I hope is a friendly amendment on line 23, right before the word cemetery? Sorry about.
That's the Western Prince William delegation working together. I love it.
Microphone teamwork. Would you be opposed to putting the word known?
Oh, sure. That's Mr. Chairman. I would tell the senator that's fine.
Mr. Chairman, I would make that amendment because I think then we wouldn't punish people if this were discovered after the fact, which if they didn't know it was there. Thank you, Mr. Chairman.
We have a motion to add the word known, and I assume staff has that. Is there a second to that motion? All right. Any discussion? All in favor of that one-word addition, say aye.
Aye.
All opposed, no. All right. That amendment's adopted.
Second.
All right, we have a motion and a second to report. If there's no further discussion, we'll vote now.
Ayes 15, no zero.
All right.
Thank you, Mr. Chairman.
Thank you very much. That bill's reported. All right, Delegate Davis. Is Delegate Davis here? Okay. Delegate Robinson.
Good afternoon.
Good afternoon.
So House Bill 214 is pretty self-explanatory just by the description of it. You know, housing authorities in the code right now, it says that you have to say the locality and then redevelopment housing authority. And my bill just adds the term or another name that the locality agrees to call it. And the reason this was brought to me by folks to allow that flexibility. Like the Virginia Housing Development Authority, it's been rebranded as the Virginia Housing, and that's all my bill does, allows that for other localities to do the same thing.
All right, wait a second. Getting a little ahead of me there, so. All right, are there any questions of the patron? All right, is there anyone who wishes to speak in opposition to this bill?
If you are in the Zoom room and wish to speak in opposition to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right. All right, we got a motion, a second, and a third. So, so if there's no other further discussion, we'll vote on the board. So,
Ayes 15, no zero.
ayes 15, no zero.
Thank you very much.
Certainly. All right, Delegate Orick.
Thank you, Mr. Chairman, members of the committee. Give your attention, please, to House Bill 231. Mr. Chairman, members of the committee, it's very straightforward. Current law allows our National Guard and other active duty military up to 15 days leave for training or military deployment. This just simply raises that number to 21 without penalty to the individual. Straightforward policy that hasn't been raised for a number of years, and with the increased demands we're putting on our National Guard and other military, I was approached by the Virginia National Guard Association to bring this bill forward.
All right, wait a second.
Mr. Chairman.
Don't get ahead of me here. All right. Are there any questions of the patron?
I have one, Mr. Chairman.
Yes.
Delegate Orick, do you know how long our Guard was deployed up to D.C. on the January 6th?
No, sir, I do not. No.
Is there somebody here from the Guard that can tell me how long our Guardsmen were deployed? All right, I just would like to know and point it out. Mr. Chairman, I'll move to report the bill. That's fine.
All right, wait, hang on. All right, is there anyone who wishes to speak in opposition to the bill?
If you are in the Zoom room and wish to speak in opposition to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right, then we'll take a motion.
Second.
All right, we got a motion and a second to report. Any further discussion? All right, we'll vote now. All in favor, vote aye. Those nay. Opposed, nay.
Ayes 15, no zero.
All right, ayes 15, no zero.
Thank you, Mr. Chairman, members of the committee.
Certainly. All right, Delegate Coiner.
Good afternoon,
Go ahead,
Mr.
go ahead.
Chair. I do have a substitute, Mr. Chair.
All right. All right, we got a motion and a second to adopt the substitute. All in favor, say aye. Aye. All opposed, no. All right. All right, we got it all set here. Okay.
Set.
Okay.
So my
Please
House
tell
bill,
us what's in the substitute.
so my House Bill 282, I've been working with Senator Morrissey to make it identical to his Senate Bill 409. So the substitute conforms my bill to his 409 and adds a reenactment clause and a technical amendment on line 47. And the senator is in the House committee right now doing the same reenactment and technical amendment so that our bills will be identical when they leave both bodies. So that's what the substitute does.
Move to report.
Wait a second. Yeah. Yes. Hobie. Huh? Yeah, I got it. Yeah. All right. Is any questions of the patron? All right. Does anybody wish to speak in opposition to the bill?
If you're in the Zoom room and wish to speak in opposition to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right. This is. All right. It's report and re-refer to finance. Is there a second? All right. Second on that. Any further discussion? We'll we'll vote. All in favor, vote aye, and those opposed, vote nay.
Ayes 15, no zero.
All right. Thank you. That's reported. All right. Next, Delegate Davis. You were not here just a couple minutes ago when.
Thank you, Mr. Chairman. Mr. Chairman, I have House Bill 384. House Bill 384 is just a freedom of expression bill, and all it says is that that no employee of the Commonwealth, this is Section A, and a local government body, Section B, basically, shall be penalized for expressing their views regarding a current proposed regulation, rule, policy, or position, or other action of government during the public comment period when that employee is speaking on their own behalf as a member of the public. And that's essentially all the bill does. And obviously, it does not provide this protection to those that serve at the at-will of an elected official.
All right. Any questions of the patron? All right. All right. Is there anyone who wishes to speak in opposition to the bill?
If you are in the Zoom room and wish to speak in opposition to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right. All right. We have a motion to report. Is there a second?
Second.
All right. If there's no further discussion, vote on the board.
Ayes 14, noes 1.
All right. Ayes 14, noes 1.
Thank you, Mr. Chairman.
Thank you very much. And the bill is reported.
Mr. Chairman, having voted on the prevailing side of HB 384, can we reconsider that vote?
All right. We have a motion to reconsider. The vote we just did
Mr.
on
Chairman, I
384.
voted incorrectly on a proxy for someone. That's why we're going to redo it.
Okay. All right.
Mr. Chairman, I withdraw the motion.
All right.
You want it on the board, or you wanted to just mark it?
They do want to reconsider it.
All right. Well, motion is to reconsider. All right. All in favor, vote aye. But those opposed, no.
Ayes 15, no zero.
All right. The bill is to be reconsidered. Is there a motion? Okay, we got a motion to report and a second. And there being no further discussion, vote aye if you're in favor and nay if you're opposed. So.
Ayes 11, noes 4.
All right. All right. The bill is reported. All right. Delegate Van Valkenburg.
Good afternoon, Mr. Chair, members of the committee. There is a substitute. 586.
586. All right.
So 586 is about preventing fraud in the emotional support animal world. And so I guess what I'll do is I'll talk about the top line of what the bill is, and then I'll go into the substitute to go over the changes. And so essentially what it's seeking to do is two things, which is one is it provides for a class 4 misdemeanor, which is like public intoxication, when a person knowingly and willfully misrepresents themselves as needing an assistance animal. And it makes it an offense under the Virginia Consumer Protection Act to provide fraudulent supporting documentation that verifies the need for an assistant animal. Now, the substitute comes after a week of working with a bunch of different stakeholders. We worked with the Office of the Attorney General.
All right.
Second.
We have a motion for the substitute. A second. All in favor, say aye.
Aye.
All opposed? All right.
So
Proceed.
we
Tell us
worked with
what's in the substitute. So.
We worked with the Attorney General, HUD, DPOR, Apartment Management Association, and Apartment and Office Building Association to alleviate concerns that the bill would be inconsistent with the Federal Fair Housing Act and any effect new language would have on our substantial equivalency status. So this substitute still holds bad actors accountable, the ones who are knowingly committing fraud, while also alleviating concerns on the type of therapeutic relationship and the kinds of documentation that should be submitted when seeking this accommodation. So lines 43 to 46 defines what fair housing testing is. This was a suggestion from Home when there was a concern that the bill would conflict with their ability to do investigations. Lines 108 to 112 in the substitute returns section C to the original code section and removes the in-writing requirement for documentation, which was a concern with HUD and DPOR. Lines 115, after the word verify, adds the language, the reliability of the individual or entity providing documentation, and this bakes existing DPOR regs into code with the interactive relationship over verifying this.
Yes.
I apologize
Senator
for
Stewart.
interrupting. I cannot find the substitute. I just have a simple question for the patron. May I ask?
Yes, yes.
Thank you, Mr. Chairman. Delegate, does your substitute still make it a criminal offense for somebody to say they need their dog?
No, it makes it a class 4 misdemeanor if you willfully and knowingly commit fraud to say that you need an emotional support animal when you don't.
Mr. Chairman?
Yes, Senator Stewart.
Why do we need this bill?
Because, Mr. Chairman, members of
Yes.
the committee, because we have people both on both sides. So people on the verification side where you can go online and get a certificate that says you need an emotional support animal. And on the side of people trying to get it, oftentimes college students sometimes saying, well, I need an emotional support animal to go. But you go to apartments where no animals are allowed, and you can provide this verification that you need an emotional support animal even when you don't. And I think that does a disservice to people who actually need an emotional support animal, and I think it does a disservice to people who are trying to live in a community where there's not animals, and that's an intentional
Mr. Chairman,
thing.
one
Yes,
last
Senator
question.
Stewart.
Are you aware that a class 4 misdemeanor is in fact a criminal offense?
Yeah, it's Mr. Chair, members of the committee. Yes, it's a $250 fine. It's the same as trespassing on railroad tracks and public
Mr. Chairman?
intoxication.
Yes, Senator Stewart.
And you want to make these people a criminal?
Mr. Chair, I would say if you're willfully and knowingly committing fraud, I think sometimes that should be a crime.
All right. Anything further, Delegate Van Valkenburg, in terms of the substitute?
Lines 129 to 133, it adds the word fraudulent to section G to further emphasize that what's this going after, and then it has an enactment clause to say if there is if HUD comes back and says this isn't in effect, it would be a self-destruct enactment clause, so that we weren't in tension with federal
All
law.
right. Any questions of the patron? Yes, Senator Bell.
Mr. Chairman, question about the supporting documentation. It says that you could request it, but who would actually be the authority to support that? Because I'm a little unclear where it reads who that authority would be.
Mr. Chair, can you ask that again?
The issue about reliable supporting documentation, which is on line 112, where does that have to come from? A doctor? What source?
Yeah, so the substitute kind of goes back to what is essentially the DPOR position. There's this it's called an interactive relationship, interactive dialogue, where you say you need an emotional support animal, and you provide either documentation or some evidence of that, and then the landlord can ask at that point for written documentation, and it goes back and forth through this process to figure out if it's a valid need. And who does it, right? Yeah, it should be a doctor, right? But oftentimes there are websites, online entities you can go to that are typically out of state, where you can get a verification that you need an emotional support animal when you don't.
Mr. Chairman.
Yes, Senator Bell.
I'm a little, frankly, I have a little discomfort that we have potentially a misdemeanor, and there's, to me, it's kind of questionable where the supporting documentation could come from if it would be a website. I think that's an issue. Thank you, Mr. Chairman.
All right, thank you. Any other further questions of the?
Are you going to ask for?
Yeah, I'm going to ask for opposition in a minute.
Okay,
so, yeah.
because I have a recommendation.
Okay. All right. as long as there's no further questions of the patron, is there anyone in opposition to the bill?
If you,
I'm very much in opposition.
You'll get your chance.
Mr. Chairman, Colleen
Proceed.
Miller from the Disability Law Center of Virginia. We do oppose this bill. As I'm sure you're all aware, people with disabilities face huge discrimination in housing already. Plenty of obstacles to finding accessible housing and housing that will accommodate service animals. This is just piling on. It's really intended to scare people with disabilities from even requesting service animals, and we oppose this bill. Thank you.
All right, Senator Evan.
That witness.
Yes,
Ma'am?
Colleen, could you come back?
If without this bill, what would you do to those who would say they're disabled and commit fraud to have an animal living in a non-pet building?
Sure, Senator Evan, the legislature actually worked out a solution to this in 2017 and created something in state code that would make it fraud to misrepresent the use of an animal in a dentist's office, in a supermarket. It's not specific to housing, but we already have that protection in state code.
Thank you.
All right, next.
Thank you. I'm Isabel McLean with Housing Opportunities Made Equal. While we greatly appreciate the substitute, we still oppose this bill because the criminal penalties will discourage legitimate requests for assistance animals. We believe that a rejection of the request and resulting application denial or eviction is more than enough deterrent for fraud. And, you know, even if in the law it says you have to knowingly and willfully commit fraud to actually get the misdemeanor, we know that that's not going to get communicated to every person that's applying for requesting an assistance animal. They're just going to hear there's a possibility of getting a misdemeanor. We also want to make note that this bill adds criminal penalties to those requesting accommodations, but only a civil penalty to those that are providing false verification. And I did want to add something to your point, Senator Bell, your question that you asked. In current law, it says that only people who have a therapeutic relationship, have or has had a therapeutic relationship with the person, can offer that verification. And therapeutic relationship is defined in the law. So we urge you not to rush to pass this bill that could affect people with disabilities, could possibly affect fair housing law. We ask that you take the time to study it further. Thank you.
All right, thank you. Next, yeah.
Mr. Chairman, members of the committee, Christy Marrow with the Virginia Poverty Law Center. I would echo everything that was previously said. We do oppose the bill for all of those reasons, and I would also just reiterate that this issue was considered for quite a while by the Housing Commission in 2017. I understand they went through 26 drafts to arrive at 27. Thank you, sir. To arrive at the law that we have now, this has been fixed, and we ask you not to pass this bill.
Mr. Chairman, Alexander McCauley from the National Alliance on Mental Illness. We oppose the bill.
Okay. All right. We have, I think, a couple of people on Zoom.
Claire,
For those of you on Zoom, try to make your comments brief. We're doing a lot of bills here, so.
Claire Huerta, please unmute and begin your testimony.
Yes, Claire Huerta with the Virginia Board for People with Disabilities. We agree with the prior speakers and are concerned about the chilling effect that this bill would have on people who have legitimate need for assistance animals. We also believe that current federal and state laws are sufficient to protect both individuals seeking accommodation and the housing providers.
Thank you.
Helen Hardiman, please unmute.
Good afternoon, Mr. Chair, members of the committee. Mr. Chair, I'm glad you remembered it was 27 drafts of that bill. I was had the pleasure of being at that table in 2017 where all the stakeholders gathered and carefully considered and balanced the interests of housing providers and persons with disabilities who need assistance animals. In my professional opinion, although I'm not affiliated with any organization, I think this bill will definitely throw Virginia out of substantial equivalence and threaten, as you'll see in the FIS, a couple $100,000 for the state. So urge you to oppose the bill. Thank you.
All right. Is there anyone to speak in support of the bill?
Good afternoon, Mr. Chairman, members of the committee. Tommy Herbert with the Virginia Apartment Management Association. I would like to briefly address the concerns that came up from this side of the room from Senator Stewart. We do ask for that Class 4 misdemeanor as the penalty for this. However, we have set that penalty as the same penalty that exists for fraud in the service animal arena. And we further, in the bill, have set the standard for conviction to knowing and willful fraud, which means that by our reading of the bill, if you are knowing but not willful, willful but not knowing, you cannot possibly be prosecuted. We have great respect for the folks across the table from us and the communities that they serve. We do not want to chill legitimate requests for reasonable accommodation requests under the Fair Housing Act. However, pursuant to the law that was passed in 2017, housing providers in Virginia face an endemic amount of fraud to basically get around no pet policies, pet deposits, and other policies that all of our other tenants do have to abide by. And so I would ask the committee to please take consideration of the changes that we've made throughout the legislative process. I would point to the severability clause at the very end of the bill, which does itself act as a circuit breaker and would stop any possible problem regarding substantial equivalency with the Fair Housing Act. It basically says if HUD does have a problem with what this bill does, it would the provisions that we're passing now would immediately go out of effect. And so therefore we could not possibly run afoul of substantial equivalency, and we would respectfully say that the communities opposed to this bill could not possibly fall under those penalties. We urge you to support the bill.
Next, and you're down to about a little over 20 seconds here, so go fast. So.
I'll go quickly. Erin Barton with the Realtors. We also support this bill for all the reasons I already spoke.
Okay.
Randy Grumbine with the Virginia Manufactured Modular Housing Association. For the reasons previously stated, we support the bill.
Thank you, sir. Brian Gordon on behalf of the Apartment and Office Building Association, the Apartment and Office Building Association. We support the bill. We were part of the compromise that was reached in 2017, but with respect, that has not fixed the issue. Fraud is still very much rampant in this space where you can just buy a doctor's note online, and we're seeing a lot of that in our industry. And this is intended to try to smoke out that fraud so that we don't see additional scrutiny given to people who have a legitimate claim for a service animal. Thank you.
All right, thank you. Senator Stewart.
Brian, don't you have a civil remedy in these cases if they're committing fraud? Can't you take them to court?
I may need to phone a friend on that one. I'm not.
Well, if somebody is defrauding your apartment manager, you can certainly take them into civil court and prove that they are defrauding that individual, and the court will order the dog removed.
So my
Isn't that correct?
Mr. Chairman, Senator Stewart, my understanding is that the concern here is with the fair housing process, and if you were to deny someone, that you would be subject to a fair housing claim.
Mr. Chairman.
Yes, Senator Stewart.
I guess my question is this. Why would you pursue making these folks a criminal and giving them a criminal record versus taking them to civil court and prove your case and have the judge tell them to take the dog out of the apartment?
Mr. Chairman, Senator Stewart, I think as Delegate Van Valkenburg stated, I think the issue is that if you are committing fraud, that is a crime. And that's, I think, why we've sought to make that a crime.
Yes, Senator Stewart.
It ain't a crime unless we make it one. Fraud is fraud, and it's a civil matter unless we turn it into a criminal offense, and that's my problem with this bill.
All right. Anybody else have anything to say?
I do.
Mr.
Right.
Chairman?
Yes.
Thank you. I just want to speak on the bill before we move forward. We have done a lot of work to keep people who are intellectually disabled and mentally ill and with autism out of the criminal justice system. We've made lots of work, lots of efforts on this. I understand the intent of the bill. However, I think that I align myself with Senator Stewart here that we don't need to to do that to our most vulnerable members of our community. And it really concerns me. And at the risk of discouraging people from voting for my friend's bill, because I always respect him, I have a motion at the appropriate time.
All right. Anybody else have anything to say?
I do.
I think. Oh,
I'm handicapped.
one person to speak in support on the Zoom.
Vic Nichols, please unmute and begin your testimony.
I am handicapped. I would very much like it, having sat here and watched a number of people, as they indicated, trying to fraud things out and ride on our backs, and I'm sick of it. I am tired of being put in those positions where people look at me because I have animals. Oh, they're support animals, they're this. Handicapped people can make it through here without needing a quote unquote support animal. The reason why I'm for this is specifically because, hey, we can actually we shouldn't be looked down upon. And people that are trying to sit there and use things that are made for us so that we can make our way in the world, all they do is sit there and fraud that kind of stuff. It's not helping us. It gives us a bad name. How about doing something to get rid of these people that do this stuff and sitting there constantly in court? If all they get is a slap on the hand, they're not going to stop it. You put some criminal charges, put something serious, then they will. And those of us that actually legitimately need that issue, that's not the problem. Thank you.
All right, thank you. Senator Locke.
Thank you, Mr. Chairman. I think that given the discussion that has gone on thus far, I certainly align myself with the comments that have been made by Senator Stewart and others. And I was there in 2017 when this went through the Housing Commission. And I believe that, again, given the discussion that we've had on this thus far, I think I know where this is going, Delegate. And my suggestion would be that we send this back to the commission for some additional study, so that we can try to figure out how we can come to some resolve. Either it's going to be that, or we're going to probably have nothing. So that would be my suggestion, Mr. Chairman.
All right. Go ahead, Senator Reeves, and then I'll Senator Boysko. So.
Thank you, Mr. Chairman, and I would second Senator Locke's motion. I just wish to speak to the bill real briefly, if I may. I carried the bill in 2017. In fact, carried the first service dog bill that would help us expand for past CNI and hearing impaired individuals, which our code was antiquated. And one of the challenges that we had was complying with ADA. And what are the only questions you can ask somebody who has a service animal, which is different from emotional support, is what service does that dog provide? And I think the challenge you have here is it probably is folks coming in and saying, hey, my bunny is an emotional support element. Here it is. I don't have to pay a deposit for it because it falls under these certain guidelines, and they're taking exceptions to that, and I understand that part. But it is a different set of the code sections, and I think you have some challenges, and I think everybody wants to do the right thing. What the right thing is, I think as far as problem solving in this is very similar. But I do agree with Senator Locke that I think it needs some more time to work through all those and get everybody together. And it took a long time, the delegate, for us to get to that point with my bill in 2017. So, Mr. Chairman, that would be my motion.
All right. Senator Boysko, you want to make a motion?
If the will of the body is to send it back to committee, I would go with that.
I would move that the bill be passed by indefinitely with a letter to the Housing Commission for study.
Second.
All right, we have a motion to pass by indefinitely with a letter to the Housing Commission. All right, if there's no further discussion, all in favor vote aye, those opposed no.
Ayes 11, noes 4.
All right, ayes 11, noes 4. The bill is passed by indefinitely, but we'll see you at the Housing Commission.
Thank you, Mr. Chair, members of the committee.
All right, I have another meeting I got to go to now, so Senator Locke's going to take over here, so. You're getting a promotion here, so.
We'll be out of here.
Oh, that's right. How do I do proxy? Oh. Okay. All right, I'll do maybe, I guess. Okay, all right.
Okay, next we have Delegate Adams. Just reset. I thought I saw Adams. Okay, Delegate Bulliver.
Thank you very much, Madam Chair. This is House Bill 517. And the purpose of the bill is to update and clarify the roles of the Virginia Chief Resilience Officer. This actually came out of discussions with stakeholders over the summer that was led by the Chesapeake Bay Commission. And one of the big, points of confusion that this bill addresses is that the Chief Resilience Officer is the Secretary of Natural and Historic Resources. However, the current code actually places the resilience officer under the public safety section of the code, and so hence you have that disconnect. And so really the big change in this bill is just to simply go ahead and move that portion of the code over to the Secretariat of Natural Resources and History, so that the code actually reflects the way that this is organized in reality. In addition to moving the section of the code, bill makes it explicit that the Chief Resilience Officer is responsible for the Coastal Resiliency Master Plan. So we've put a lot of time and effort and money to go ahead and develop that. It's going to be a really great blueprint for kind of Virginia's actions in the future. And what this bill does is just simply make sure that somebody takes responsibility for that, and that would be the Chief Resilience Officer, and also directs them to provide an update to the General Assembly and the Governor every 2 years in order to be able to inform us of how that plan is being implemented. So again, I just want to thank the Virginia rep from the Chesapeake Bay Commission for bringing this all together, and happy to answer any questions.
Are there any questions to the delegate? Okay. Anyone here to oppose? I hope not. Thank you. It's been moved and seconded that House Bill 517 be reported. All those in favor, please vote aye. Those opposed, no. Okay.
Ayes 15, no 0.
Ayes 15, no 0. That
Thank
bill's
you, Madam
reported.
Chair. Thank you, Senator Mason. Thank you, Senator Stewart.
Oh, I'm sorry, Delegate. Do we have to strike? It has to go to finance.
That was my motion, Madam Chair. That was my motion.
Do we have to reconsider?
We're good. I mean, if everyone's okay with it.
Everybody, is everyone? We're good.
We're awesome.
Okay. Okay, Delegate Tater.
It has a few.
Thank you, Madam Chair. I actually have two bills.
Okay.
The first
We're
one.
only taking one, though.
Oh, you are?
Oh, I'm just
Oh. I am a freshman, but I have been hazed twice by the Senate, so.
Get used to it. Get used to it.
So the first one is HB 354, which establishes the Virginia Military Community Infrastructure Grant Program, or Grant Fund, which is basically an investment fund to support military communities in the Commonwealth by awarding grants to aid in infrastructure projects that enhance military value, installation resiliency, and quality of life for military communities. It is in the
This is identical to Senate Bill 315.
Correct.
Passed the Senate 40-0, Madam Chair.
Correct.
Move to report.
It has to be, hold on, and it has to go to finance.
It's going to finance, yes,
Yes.
that's right, correct.
Okay, it's been moved and seconded that House Bill 354 be reported and re-referred to finance. All those in favor, please designate.
Ayes 15, no zero.
Ayes 15, no zero, that bill is reported.
Thank you, Madam Chair.
Next one.
Next bill is HB 1203. This establishes the Suicide Prevention Coordinator in the Department of Veterans Affairs that will support and closely coordinate effective mental health care services for military service members and veterans and their families. It too is in the House and Senate budget, and this was brought by the Joint Leadership Council of Veterans Services Organization.
Okay, this too has to be sent to finance.
Right.
Refer to finance.
Okay. It's been moved and seconded that House Bill 1203 be reported and re-referred to finance. All those in favor, please so designate.
Ayes 15,
Thank you
no
very
zero.
much.
Thank you. Okay, Delegate Austin.
Yes, ma'am, Madam Chair. Hope you all are well today. I have two bills, if you
We
don't
are,
mind.
we don't know about you though.
In the essence of time, I have, I'll do the most important one first. Let's do that. I have HB 507 as a name, image, and likeness bill. It's identical to Senator McPike's bill. We do have a substitute on that bill.
Move the substitute.
Moved and seconded that the substitute be adopted. All those in favor, please say aye. Aye. Those opposed? Okay, we have the substitute.
Thank you. We had a substitute on Senator McPike's bill also in the House today, and it passed the body 96-4. Senator McPike's bill passed this body 40-0 on 2/1, February 1.
What's the difference in the substitute?
The substitute, I'll tell you, on substitute removes lines 34 and 35 and lines 65 through 68, and we found that the NIL, name, image, and likeness, the NCAA regulates those areas, so it was not necessary to include those areas. It puts us at a disadvantage in the Commonwealth if we include that language. So Senator Pike and I decided to strike that language.
Oh, okay, all right. Any questions? Okay. Moved and seconded that House Bill 507 be reported as a substitute. All those in favor, please so designate.
Ayes 15, no zero.
Ayes 15, no zero. That bill is reported.
Thank you, Madam Chair. I also have HB 468. It's the Botetourt County Library. It changes the library board from an advisory board. Let me make certain what I'm saying here. From a governing board to an advisory board. It passed the body 99-0.
That seems like a very serious change.
It does practically nothing. The body has no authority to do anything. They own no property. They handle no money. So they're just, they want to be an advisory board.
There's a motion to report. Is there a second? It's been moved and seconded that House Bill 468 be reported. All those in favor, please so vote.
Ayes 15, no zero.
Thank you,
Ayes
Kat.
15,
Appreciate
no
your
zero.
help, Senators.
Okay, Delegate Adams.
Thank you, Madam Chair and members of the committee. House Bill 752 was introduced following some reporting on that I read about respecting the Office of the Inspector General, and this was the past year. There was, as you might recall, an instance where we had representatives from the governor's office and or his cabinet secretaries who were reviewing a report and putting certain pressure on the inspector general. I looked at the code at that time to see, what duties were allowed under there, and was surprised that there wasn't a prohibition on a non-interference. Of course, the Office of Inspector General is one that is meant to be independent, and of course, the governor has certain powers. He has broad powers to be able to appoint the Inspector General, to remove the Inspector General, but I think it would be wise for the Assembly to put this small provision in with the rest of Chapter 3.2 of Title 2.2 to simply say that if there is a lawful investigation by the Inspector General, that there should be no interference. And that's why I introduced the bill, and I would hope that this committee would welcome that action as well.
Are there questions to the delegate?
Motion.
Anyone here?
Oh, I'm sorry.
Anyone here in support? Any opposition?
Second.
Okay. Okay, there's a motion to report the bill. All those in favor, please vote aye. Those opposed, no.
Ayes 14, no zero, one abstention.
Thank you,
Madam Chair. Members.
Did Campbell come? Okay, Delegate Campbell.
Thank you, Madam Chair. I have House Bill 1122. And, Madam Chair, this bill essentially provides that the Commissioner of the Department of Motor Vehicles, upon request, would have to furnish vehicle information for a manufactured home to a enumerated list of individuals set forth in the bill. You might be wondering what on earth would have precipitated this bill, especially if you consider reading the first paragraph in 46.209.1, because a plain reading, and when you look back at the definition of vehicle in the code, you begin to wonder, how on earth a commissioner could interpret that code in this code section as to not allow them the authority to be able to deliver that information to a prospective purchaser. But that's the way it's been interpreted. This has caused a lot of problems, especially in rural areas where those manufactured homes very often are located on real property that isn't owned by the owner of the manufactured home, and then subsequently they try to sell the real property and have a difficulty in being able to ascertain the owner of the manufactured home. This essentially would just allow for the commissioner to be able to give that information to the prospective purchaser or the real estate agent that may be handling the transaction.
Are there any questions to the delegate? Anyone here in opposition?
If you are in the Zoom room and wish to speak in opposition to this bill, please raise your hand electronically now. Madam Chair, there are no speakers.
It's been moved and seconded that House Bill 1122 be reported. All those in favor, please vote aye. Those opposed, no.
Ayes 15, no zero.
Ayes 15, no zero. That bill is reported. Thank you, Delegate.
Thank you, Madam Chair.
Delegate Bennett Parker.
Thank you, Madam Chair. This is House Bill 444, which is the companion of Senator McPike's Senate Bill 214 about electronic meeting authority. I have an amendment in the nature of a substitute.
It's been moved and seconded that the substitute be adopted. All those in favor, please say aye. Aye. Those opposed? We have the substitute.
Thank you. The substitute, like the bill, is a consensus of the Virginia Coalition for Open Government, the Virginia Press Association, VML, and VACO. The underlying bill was also a recommendation of the FOIA Council. The substitute adds additional guardrails and clarifications. First, it clarifies that remote participation by individuals requires an in-person quorum. Second, it includes language to ensure that an in-person meeting cannot be switched to a virtual meeting without a new meeting notice process being initiated. Third, it further limits the holding of all virtual meetings by not allowing 2 virtual meetings to be held consecutively. Finally, it requires that the policy that the public body must adopt at a public meeting with a recorded vote must describe the circumstances under which an all-virtual public meeting can be held. The code does not currently allow any public body to hold a virtual meeting outside of an emergency. This applies to the boards of visitors and boards of trustees of our institutions of higher education, local advisory bodies like the Berryville Tree Board, the Chesapeake Public Art Commission, and so forth, state advisory boards and commissions like the State Council on Women and the Virginia Board for People with Disabilities, as well as state work groups. And it includes regional bodies like planning district commissions and transportation commissions that can have members from 15 or more different jurisdictions. The code does not allow any of these bodies or even their subcommittees to hold a meeting without a physical quorum in the room. A majority of other states did allow this even before the pandemic. The bill is permissive and not mandatory, and it does not apply to the General Assembly. It is also limited. Last year, around 400 people from across the Commonwealth weighed into the FOIA Council in support of this flexibility. The FOIA Council also heard from groups representing seniors, women, and people with disabilities, as well as bodies like Go Virginia Region 6 and the Southside Planning District Commission, highlighting the importance of this bill to rural areas. Many people and organizations across the Commonwealth would like to see this bill passed, and so I hope it is the will of the committee to report the bill. Thank you, Madam Chair.
Are there questions to the delegate regarding House Bill 444?
Yeah, Madam Chair.
Senator Eben.
I would ask Delegate Bennett Parker, we had passed similar legislation out of Committee 10-5, but you said you put additional restrictions on, being one that was that there couldn't hold 2 virtual meetings in a row.
Correct.
Was there another restriction that you mentioned?
It also, let's see, it clarifies that you cannot switch an in-person meeting to a virtual meeting without a new meeting process being initiated. And it clarifies that the policy that the public body must adopt at a public meeting with a recorded vote must describe the circumstances under which an all-virtual public meeting can be held.
So in other words, you have to explain why you're holding a virtual meeting, and that was not previously in the bill.
The policy would have to describe the circumstances under which it's held. The underlying bill limitation on 2 or 25% still holds.
Thank you.
Are there other questions? Those in opposition to this bill?
If you are in the Zoom room and wish to speak in opposition to this bill, please raise your hand electronically now. Madam Chair, there are no speakers.
It's been moved and seconded that House Bill 444 be reported. All in favor, please vote aye. Those opposed, no.
Ayes 12, noes 3.
Ayes 12, noes 3. That bill is reported. Thank you,
Madam Chair,
Delegate.
members of the committee.
Delegate Weber. Did I say that right?
Close enough.
Hello, Madam Chair. I have two bills before you. Is there an order in which you would like me to take them, or just
Whatever helps you.
I don't know if either will. Well, let's first go with HB 1259. I'll do a quick, brief description, and then if there's questions to dive into the weeds or anything, I do have somebody here, a phone a friend, to be able to hopefully answer all of those questions. The substitute that I brought from the House for 1249.
You have a substitute?
No, this is the bill that passed the House. Sorry.
Okay.
Proposes a narrow exemption with the Virginia Consumer Protection Data Act to preserve the beneficial uses of certain demographic data while retaining the strong privacy and anti-discrimination protections contained in the underlying act. As enacted, the VCDPA protects Virginia consumers' privacy by defining certain personal information as sensitive data that can only be processed with a consumer's consent via an opt-in provision. What HB 1259 seeks to do is to ensure Virginia consumers will continue to enjoy certain or all benefits of responsible use of personal demographic information. It will allow the use of sensitive data for marketing outreach efforts that bring information to consumers in a way in which they expect, while maintaining an opportunity for a consumer to opt out if they so choose. And the bill. So basically, what the bill does is it tries to allow certain marketers, so for instance, nonprofits, et cetera, to be able to provide information to consumers, i.e. vaccinations, financial data, things like that they would normally not be able to disseminate to the consumer. And that's what the bill seeks to do.
Are there questions to the delegate?
Yeah, Madam Chair.
Senator Eben.
Yeah, in terms of the sensitive data, I'm just trying to get some examples. So like it says, that data revealing someone's sexual orientation would only be considered sensitive if used to make a decision that results in legal or similarly significant effect for a consumer. So if you wanted to advertise Gay Pride Day and get people who they think are gay to see that on the internet, it would allow cookies to use that? Is that what that does?
Essentially, basically what they're trying to do is so for instance, COVID-19 vaccine or other sensitive data, they're trying to reach those demographics so those folks can utilize that information.
Could you give me an example in the other direction with any of the categories of what would not be allowed?
I would leave that to
this legal or similarly significant effect for a consumer?
So I have Chris Oswald here. He can probably answer those questions a little better than I can, Senator.
Thank you.
Madam Chair, thank you. Members of the committee, my name is Chris Oswald. I'm with the Association of National Advertisers. We're the oldest and largest advertising and marketing trade association in the country. We represent over 1,500 companies as well as nonprofits and charities within our organization. And specifically what, as Delegate Weber put forth in our bill, what we're trying to do is seek to fix what we identified as a concern as the act was being going through the process last year. Specifically, the use of demographic data has been used by marketers and advertisers for decades, including nonprofits and charities, as you highlight, Senator. And one of the things that the Act does right now is it does not allow for use of that demographic data, and again, it's just that narrow provision within sensitive data to be used as it has been for years and throughout the country. Specifically to your question, Senator, it's a great example. If you are hosting a gay pride event, for sure you want to be able to identify those audiences that may want to participate, whether they're gay, whether they're not. In other contexts, if you are a charity, a faith-based charity, you want to identify those audiences that may be willing to donate to your cause, et cetera. And so what this bill would do is it would allow for the opt-out use of that data. Right now, the law stipulates that it has to be opt-in. We just know from experience that individuals don't opt in to sharing their data generally. It's like maybe 10%. What we are trying to do is allow the beneficial use of this data and still provide all of the protections that exist within the Act. By allowing for the beneficial use and keeping all of the other protections within the Act, we think that we will avoid essentially excluding those populations and those audiences that the Act is specifically designed to protect with this sensitive data provision. And with that,
Madam Chair, just to follow up.
Keep in mind, we have to be done by 4 o'clock.
Okay, this is my final question.
Okay.
What I'm trying to figure out is under what circumstances would they not be able to use the data? Can you give me an example of, say you check accept cookies or you don't, in this case, you don't, and they know that you're either, Jewish, Catholic, whatever, black, white. When would they not be able to use that data?
Madam Chair, Senator, right now, as the Act is provided for, that data is off limits for those populations within the definition, unless the individual positively opts into sharing that data. And that is more extreme than what we've seen in any other privacy bill throughout the country, with the exception of Colorado. Not even California goes this far. And quite honestly, I cover all 50 states for the association. And even those states that are looking to sort of replicate what Virginia did last year in passing the Act, Iowa, Indiana, Utah, they recognize this as a problem and they are fixing it along the lines of what we're attempting to do with this bill.
Okay, are there those here in support of the bill? You have 2 minutes.
That's the answer to his question right there. Is the definition. Yeah, gotcha.
Those in support? Are there those in opposition?
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now.
I've been waiting to speak.
Yeah, Jay Spear with the Virginia Poverty Law Center. We are opposed to the bill. As the previous speaker said, there is no restriction on them using this data. They simply have to get the consumer's permission. And they're trying to change the law that was just passed last year to say you don't have to get the consumer's permission. Now, we have tried to work on compromise language over the last few weeks, but it's a very complicated issue. We've not been able to reach agreement. We would ask this committee to put a reenactment clause on this so we can talk about this more before we make such an important change. Thank you.
Thank you.
Madam Chair.
Let us finish with the speakers.
Madam Chair.
Let me finish with the speakers.
Thank you.
One additional speaker in opposition.
Keir Lamont, would you please unmute and begin your testimony?
Thank you, Chair Locke and members of the committee. My name is Keir Lamont with the Future of Privacy Forum. Last year, FPF had the honor of participating in the Joint Commission on Technology and Sciences work group that issued recommendations concerning the Virginia Consumer Data Protection Act. In enacting the VCDPA, Virginia recognized that sensitive categories of personal information, such as health data and religious beliefs, should be subject to increased protections and privacy rights as a default. This approach was then followed in Colorado and is currently under consideration in approximately a dozen additional states in active privacy legislation. However, as drafted, HB 1259 would depart from this approach, taking Virginia out of sync with leading American and global privacy standards. Thank you for your time.
Thank you very much. Senator Hashmi.
Thank you, Madam Chair. My question, and sorry about the static. My question was just to, and I'm sorry, the director of the association. In our conversation earlier this morning, you shared that this really covers a pretty significant extent of privacy information. Thank you. And this includes citizenship, immigrant status, religious and faith affiliations. It's just a pretty significant dive into an individual's privacy information. So we have the option for people to opt out, to opt in to share this information. So what is the benefit to the consumer to actually have to physically make that conscious decision to opt out? So many communities simply don't even have access to the technologies that would enable them to opt out from sharing this universal data.
Madam Chair, Senator, thank you. While the categories of the demographics are exactly as you say, the actual use that the bill proposes is quite limited. They can only be used for marketing, advertising, fundraising, or other beneficial purposes. Going back to Senator Evans' question, where it is not allowed is if there is a legal effect, i.e. if this data is used or decisions are made that are discriminatory or already illegal under federal or Virginia law. Moreover, the protections in the Act that would have a significantly similar effect to a discriminatory decision-making process, that's also out of bounds. And so, Madam Chair, what we have tried to do in working with the Poverty Law Center is really narrow down the use of this data for only beneficial purposes and not basically exclude these particular populations from the advertisements for the fundraising requests that they have that are tailored towards these demographic groups.
Senator Bell.
Thank you, Madam Chair. My concern is on line 38, the information sharing which is allowed. Once that third party who gets the information, what restrictions do they have on use or what they do with this data?
Madam Chair, Senator, the restrictions on the use of this type of data remain. The protections within the Virginia Act, within the federal use of data and restrictions remain. And if it is used for any other purpose other than for advertising, marketing, or anything else that essentially would be discriminatory or disadvantage these populations, it's out of bounds. And that exists in the law. We're not touching that. Again, what we're trying to do here is allow for these populations to enjoy the beneficial use of this data set so that they can have messaging tailored towards them and they don't effectively get shut out of what others may enjoy.
Senator Evans, Senator Boyce-Scott, keeping in mind, look at the delegates. We have to be out of here at 4 o'clock.
Madam Chair, I apologize, but I heard Madam Chair say we need to get this over. This bill, with all due respect to my friend from Fauquier, whom I think the world of and respect deeply, needs more work than we're going to do on it this year. And so I would gently suggest we pass this bill by indefinitely.
Second.
It's been moved and seconded that House Bill 1259 be passed by indefinitely. All those in favor, please vote aye. Those opposed, no.
Ayes 9, no 6.
Ayes 9, no 6. That bill is passed by indefinitely. Delegate, you have a second bill?
Yes, ma'am. Madam Chair, I have HB 244. HB 244 is basically, it's an extension of something that we started working on 4 years ago. At the beginning of the Northam administration, working with Secretary Lane, we passed a red tape reduction pilot program. Many of the folks in this room voted for it as it passed the Senate. The pilot program passed the Senate unanimously. This regulatory program was wildly successful despite the pandemic, and over the past 3 years, the two agencies involved in the program strive to cut regulatory requirements 25%. While DCJS was not as successful, mostly due to the pandemic, I'm proud to say that DPOR cut regulatory requirements 27%. What HB 244 seeks to do is to expand what we accomplished under 883 to the rest of the executive, with some modifications because of lessons learned and improvements from the pilot program. HB 244 creates a regulatory budget program with the Secretary of Finance, which works with the various agencies to create a regulatory catalog that identifies the type and total number of regulatory requirements and regulations currently promulgated and any state and federal mandates that require such regulatory requirements. And to work with each agency to set targets, 1, to reduce, if can, 3, to maintain, and also, if they must increase, hopefully by targeted amounts. The bill also asks the department to create and maintain a regulatory town hall which will catalog and publish all the relevant regulatory information. The bill also gives a methodology for agencies when identifying a regulation or regulatory requirement that requires a change in state law and initiating rulemaking changes, as well as a system of reporting to the General Assembly as the successes and reasons as to why the goals are not met. Basically, it expands on what we did 4 years ago with the Northam administration, and we got the idea from British Columbia when they did this in the 90s, and it has only helped basically streamline government and make it much more consumer-friendly. And that's what the bill seeks to do, Madam Chair.
Are there any questions?
Madam Chair.
Anyone here in opposition?
Madam Chair, could I ask a quick question?
Senator Stewart.
I promise it's going to be quick. Wasn't this one of the issues that Governor Northam ran on, Delegate?
Yes, sir.
I thought I recalled that.
Sorry, I have a substitute. Right?
There's a substitute?
Yeah, to.
Move the substitute.
I've got it right here.
Moved and seconded that the substitute be adopted. All those in favor, please say aye.
Aye.
Those opposed? Okay.
To answer to the Senator, yes, and we had a great partner in Secretary Lane when we did the pilot program.
What's different about the substitute?
It basically rewords things to make it much more functional, technical, et cetera. Right? What else does it do?
Fiscal impact.
Oh, it helps remove the fiscal impact.
Oh, okay. So we don't have to send it to the killing fields of finance?
Well, I mean, I lost a few the other day, so.
Second.
Okay, it's been moved and seconded that House Bill 244 be reported. All those in favor? It doesn't have to go to finance?
They asked for it.
Oh, they asked for it?
Language out?
We send it anyway since they asked for it.
Still have to go?
Okay.
That's the motion.
Okay, it's been moved and seconded that House Bill 244 be reported and re-referred to finance. All those in favor, please say say aye. And those opposed, no.
You'll be okay. I just want to check it. They're going to have a finance meeting then?
Ayes 12, noes 3.
Ayes 12, noes 3. Is reported.
Thank you, Madam Chair.
Thank you. Delegate Carr.
Thank you, Madam Chair. We want to do 642.
Madam Chair, is this the same bill that we passed unanimously and passed the Senate 40-0 in SB 719?
I do believe that it is.
Second.
Okay, it's been moved and seconded that House Bill 642 be reported. 642? Finance. It has to go to finance. This is 642, right? Okay, it's been moved and seconded that House Bill 642 be reported and re-referred to finance. All those in favor, please vote aye. Those opposed, no.
Ayes 15, no 0.
That one's reported. Delegate Carr.
Thank you, Madam Chair. Then House Bill 644 is an agency bill. It resolves an inconsistency in the current code regarding the timing of when DGS may proceed to sell surplus property and allows DGS to work with the owners of the land that is adjacent to surplus property to adjust boundary lines and grant easements to facilitate the sale. These actions are subject to written approval of the governor. Finally, the bill streamlines the advertising process by requiring the advertisement of the property in one newspaper that is circulated in the locality in which the surplus property is, as well as posting the property on DGS website. I believe there's somebody from General Services here to speak on the bill if you have any questions. Or maybe
Okay, are there any questions to the delegate?
Move the report.
Second.
It's been moved and seconded that House Bill 644 be reported. All those in favor, please vote aye. Those opposed, no.
Ayes 15, no 0.
Ayes 15, no 0. That bill too is reported.
Thank you, Madam Chair.
Thank you,
Member of
Delegate
the
Carr.
committee.
Delegate Hodges.
Good afternoon, Madam Chair, members of the committee.
Hello.
You have before you House Bill 191 dealing with healthcare workforce, and of course, we all know the healthcare workforce crisis that we are in. Of course, many of us live it and breathe it. I'm talking to doctors and nurses and behavioral health, working on the the hospital board as well. We live it and breathe it. And there are a number of challenges with regards to healthcare that the private sector doesn't see. Of course, it's highly regulated, not only under the boards, but then you're looking at the reimbursement side for Medicaid and so forth as well. So there are a number of challenges and a number of barriers. And in solving this, we have a number of folks that are in groups that are out there working on this. We have the Healthcare Workforce Authority, we have colleges, universities, community colleges, we have private sector, health systems, you name it. They're trying to work on it, but what we don't have is really a coordinated effort to bring this all together and make it work. So what we're doing here is creating a position, I'm sorry, I do have an amendment, I believe. Did he get you that? Or I can do that. Did you have that? I believe it's two places, I'm sorry. Or we can do it at the end. Yeah, move it for a second. Okay, and I'll speak to that at the end.
Okay, there's a motion and a second to move the amendments. All those in favor, please say aye. Aye. Those opposed, the amendments have been adopted.
Thank you, Madam Chair. So what we're looking at is a coordinated effort to bring this all together to fix this. Now, you typically think of it falling under the Secretary of Health, but this is really a workforce issue as well. So, not only are we looking at under the Secretary of Health, we're placing the special advisor under Commerce and Trade to work across all secretariat positions to work together to overcome the barriers and to try to find ways to solve this. In addition, Madam Chair, it also creates a fund, the Virginia Health Workforce Development Fund, which will work to provide incentives for the removal of barriers in education and training and so forth for healthcare workforce. So we're trying to coordinate this and bring it all together. Of course, if you embrace the policy, it will go into finance. There was not a Senate companion, and it is in the House budget, Madam Chair. So that's the quick version. I know you're trying to get out of here, but I can go on and on. But I think we all realize it's such a big issue.
Madam Chair?
Are there questions? Senator Eben.
Just real briefly, does the administration support this great idea?
Yes.
Thank you.
Yes, thank you.
Are there other questions?
And it does have a sunset on it as well, so we can look to readdress it if we prop it up and make it work. So I wanted to put a sunset on there. So I'm sorry, Madam Chair.
Okay. Anyone in opposition?
Second.
Can I see if I have any opposition?
Nope.
If you're in the Zoom room and wish to speak in opposition to this bill, please raise your hand electronically now. Madam Chair, there are no speakers.
Okay, now you fast people.
Second.
It's been moved and seconded that House Bill 191 be reported and re-referred to finance. All those in favor, please vote aye. Those opposed, no.
Ayes 15, no zero.
Ayes 15, no zero. Bill's
Thank you very
reported.
much.
Thank you. Delegate Wright.
Thank you, Madam Chair. Members of the committee. House Bill 1360, it authorizes the Adjutant General to facilitate and coordinate efforts to promote participation in the state-sponsored group term life insurance program offered to members of the Virginia National Guard. And let me say before we go any further, the number on line 13, there's been some questions raised about the fact that it says that the Adjutant General shall. The Adjutant General is the official sponsor of the Virginia National Guard state-sponsored life insurance program. And the problem that we found is that many members of the Virginia National Guard aren't aware of their benefits. And it's $1,000. It doesn't cost the state any money. It's authorized by the United States Public Law Code. And so that's what the bill basically does. It says that the Adjutant General shall, it does not directed at this Adjutant General necessarily, but it is spelling out that it's his responsibility to see that the National Guard members are made aware of what what's available to them, and it helps us to retain and recruit National Guard members. And heaven knows we need all the help we could get in doing that. So that's the bill. I'll be glad to try to answer any questions.
Thank you, Delegate. Are there any questions?
Madam Chair.
Senator Reeves.
Delegate, I know we spoke briefly. What's in place right now to require the Adjutant General to promote this secondary life insurance to Soldiers Group life insurance?
Well, the fact that he's the official sponsor of it, and he's, for instance, some unit leaders may be uncomfortable in trying to schedule conferences and training sessions to make members of their units aware of what's going on. And this is a responsibility and the duty and falls under the category of what the Adjutant General does. So he's the man in charge or the woman in charge. And I really think it's important that for future Adjutant Generals that they realize this is a responsibility that falls on them. It's not, they can't just expect someone at the local level or whatever to do it. And I was requested to put this legislation in by the JLC, and so that's the bill.
Madam Chair, follow-up question.
Senator Reeves.
So typically when members of the Guard or even regular Army go in, they're given a packet of information. They'll sign up for their Soldiers Group life insurance. This is a supplemental policy that we're asking by a private entity through the National Guard Association to promote really through the association and this private entity that's providing that. Isn't that correct?
Well, there should be people here today from the National Guard that would have more specific information on that. I know when the bill came through the House, there were 4 or 5 people that were there to testify to it, and they've been informed of the meeting today. But this is a program that is available to the National Guard members, and like I said, the problem they're having is finding out that the program exists, and a lot of them are missing out on this benefit.
I understand. Thank you, Madam Chair.
Further questions? Anyone in opposition to this?
If you're in the Zoom room and wish to speak in opposition to this bill, please raise your hand electronically now. Madam Chair, there are no speakers in opposition.
Motion on the bill. Moved and seconded that House Bill 1360.
Madam Chair, substitute motion
Okay.
to PBI the bill. Madam Chair, I'm happy to speak to it. I spoke with the member about putting a may instead of a shall to direct the Adjutant General. And if you look at the requirements of what they're asking the Adjutant General to do within the limited time frame that they have to train, this would take quite a bit. I don't think it's the role of the Adjutant General to promote private insurance to his soldiers. While he has to make it available to them, it's not his job to be an insurance salesman. And Madam Chair, I just think that's the wrong role to put that in there. I'm happy if the delegate would be amenable to a may, change the shall to a may, but I can't let that go forward with the limited time that we have with the role of our National Guard. So if the delegate would be amenable to a may instead of shall, I'll withdraw my motion, but if he can't, then I'm going to proceed with my motion.
I feel just as strongly that in good conscience, I can't change a shall to a may when it comes to the National Guard members who are not getting the information that they need.
Okay, but I didn't hear a second to your motion.
Madam Chair,
Delegate.
could I offer another suggestion? Perhaps understand where you're at and where the senator's at. Perhaps we change it and you reject it when it comes over and goes to conference. We have more time to work it out since time's limited today.
I'd prefer up and down vote. I'm not going to change on.
Thank you, Madam Chair.
This was presented to me. It's not my business.
But I didn't get a second to Senator Reeves's motion.
Second.
Okay, it's been moved and seconded that House Bill 1360, did you say PBI?
Yes, ma'am.
To be passed by indefinitely. All those in favor, please vote aye. Those opposed, no. This is to PBI.
Ayes 5, noes 9, 1 abstention.
Ayes 5, noes 9, 1 abstention.
Madam Chair.
Yeah. Who was that?
Oh, sorry. Remember.
Okay. Okay, we go back to.
Move to report. Second.
It's been moved and seconded that the bill be reported. All those in favor, please vote aye. Those opposed, no.
Ayes 11, noes 4.
Ayes 11, noes 4. Your bill's reported.
Thank you.
Delegate McGuire.
Thank you, Madam Chair. Today I'm presenting House Bill 358. It's very similar to Senate Bill 572 with Senator Kagan's. It passed the Senate floor 40-0. And basically, it's we want Virginia to be the most veteran-friendly state.
I have that it's identical.
Second.
No argument.
It's been moved and seconded that House Bill 358 be reported. All those in favor, please vote aye. Those opposed, no.
Ayes 15, no 0.
Ayes 15, no 0.
Thank you, Madam Chair.
Okay. Delegate Hope. If you can be equally as fast, you'll make us happy.
Good afternoon, Madam Chair, ladies and gentlemen. This bill, House Bill 1197, directs the Office of Secretary of Public Health, Public Safety and Homeland Security and the Office of Secretary of Health and Human Resources to bring together a work group. So this is a Section 1 bill to determine the feasibility of transferring responsibility of the Department of Juvenile Justice from the public safety to Health and Human Resources. The paradigm shift that we've seen throughout the country and even Virginia is away from, when it comes to juveniles, away from punishment to rehabilitation. And if you think about all the services people that get into this situation, they need mental health mental health treatment, maybe counseling. They need substance abuse treatment and things like that. So it's already a lot of stuff and services that they're using other health and human resources. So this just puts a work group together. It doesn't make any preconditions or notions. It just brings everyone to the table and see what's the best place for governance and helping our juveniles.
It's been moved and seconded that House Bill 1197 be reported. All those in favor, please vote aye. Those opposed, no.
Ayes 14, noes 1.
Ayes 14, noes 1. The one was Frank.
I remember that. Thank you, Madam Chair.
Thank you. Okay, I don't see Delegate Bell. It's not here. Delegate Krizek.
Thank you, Madam Chair. This is Senate or House Bill 765, I believe, right? This is exactly the same as Senate Bill 402, Senator Reeves' bill.
It's identical to Senate Bill 402. Okay, it's been moved and seconded that House Bill 765.
Madam Chair, before we vote on it, it is exactly the same. Let me just preface this with, yesterday my bill was heard in the House. There was some discussions about some language that would help with regard to Texas Hold'em. They're going to make that amendment on my bill over in the House, and we promised that to happen, but we'd like this bill to go through because that will help. My bill will help as it goes through the folks that are involved in Texas Hold'em. So that is some of the argument, I think.
Madam Chair, I want to.
Does this have to go to Finance?
Madam Chair, I was just going to point that out. The previous bill, 402, actually went to Finance.
He's saying no. Okay. It's been moved and seconded that House Bill 765 be reported. All those in favor, please vote aye. Those opposed, no. Oops. I didn't mean to do that. Okay.
Ayes 15, no 0.
Ayes 15, no 0. That bill's reported.
We'll take care of you, Dave.
Okay. Delegate Cardoza.
How you doing, Mr. Chair? Madam Chair, I am here to present HB 1206. It will create a facilities management department for Fort Monroe, which is badly needed so that they can perform repairs without having to involve expensive contractors.
Okay, are there any questions to the delegate on House Bill 1206? Just creating a facilities management department for the authority?
Yes, and it will also add I also have a budget amendment that will pay for them to pay those people and buy some equipment initially in the first year.
Hobie, does this have to go to Finance? Because I don't remember seeing this on our side. Okay.
So, Madam Chair, question. How do they do it now?
They have to hire contractors who are charging expansive amount of money. The issue is that since it's historic, they have to hire certain contractors, or they could just have facilities management people who could do it for their paid employees, but they do it at a much less expense. So,
thank you,
Madam Chair.
I have a question.
Yes, ma'am.
I sit on the authority.
Yes, yes, ma'am.
I do not recall seeing this as a part of their legislative package.
I'm also on the authority. It was a request made specifically by the director, former delegate Glenn Oder, and that when he made that request to me, and I said, you guys have a facilities management department. I said, no, that would be a great idea if we could do that. And I said, we can do that.
In conversation?
Yes. And I talked to him about it, and he said it was a great idea, and we did it.
All righty then.
Madam Chair, I got a silly question. Don't you all typically adopt resolutions if you want something done?
That's been the procedure.
Yeah, that's typically what we do. No offense, Delegate, I just was curious.
Madam Chair.
Senator McPike.
Thank you, Madam Chair. Just a question for the patron. The existing code already sets up the authority as the management agent. Why is this bill needed?
Because they don't have the ability to perform those. So the facilities management will have the ability to perform those actual repairs themselves, which will be employees of the authority. Right now, all they can do is hire out someone else.
Follow up, Madam Chair.
Senator McPike.
So, line 35 of the bill, the 6/7 words in are what?
I'm not sure. I can.
It's your bill.
I can look it up real quick, but I'm not sure.
Well, Madam Chair, I'll shorten it. It says management agent. And management agent is a very broad entity. I'm not sure how better we can define in the code just to pursue the business of managing the facility.
Well, this would require hiring specific people. As far as I was informed that they don't have the current authority to do this. And this would add that.
Madam Chair, I just maybe defer to council. I mean, the existing code seems pretty broad. Not to put council on the spot, but I would interpret it to mean they can hire staff, they can do many things as the management agent on behalf of the Commonwealth to manage this asset.
Well, I will also say this.
Madam Chair, this is a question to council, not to the patron.
Madam Chair, Senator McPike, I don't think council wants to do any harm to this bill. We'll defer answering that one. Thank you. We're not going to answer that one. Thank you.
So I will say this also includes the funding to hire these people.
Madam Chair.
Senator Bell.
Looking at the FIS on this, it's about, what I'm adding up in my head is $2.3 million. Do we have anything from the board, a letter or anything, if we don't have a resolution saying that they want this? Because I think before we spend $2.3 million, we should have some, it's a $545,000 the first year and then $301 every year after that, it appears.
So, well, I would say that in House committee testimony, the director came and explained it himself.
I mean, if we pass this, it will have to go to finance. Senator Donovan.
Just a question in general, and maybe for the patron. How are these contracts for the services currently funded, and who pays? Does the state pay now for the more expensive contractors?
Yeah, everything with Fort Monroe Fort Monroe is owned directly by the state. So every dime we spend is coming out of the state budget. So if we are able to do this in-house, we will be saving the state a substantial amount of money.
Madam Chairman, further question.
Senator
So
Donovan.
the fiscal impact that I looked at does not account for the savings of doing this, often in-house is less expensive than contracting out. So this talks about the actual amount, but it doesn't really relate that to the savings for the state.
Yeah, that does not relate to savings.
Madam Chair.
Senator McPike.
Sorry, just one follow-up question, I guess, if we can, to the patron. So under 2.22339, this section, duties and authorities, can you read to me lines 22 to 23?
22 to 23?
This is what the current code and the current authority of the board.
22 to 23.
So number 2.
To hire and develop professional staff, including executive director and other staff as necessary to discharge responsibilities of the authority. Well, I'm aware they are able to hire those people, but they're not currently in their budget. They don't have to hire people for this specific purpose.
Madam Chair, I guess speaking to the bill.
Senator McPike.
Thank you, Madam Chair. I mean, it's clear to me that the current code under this section gives the authority of the entire ability to do what they're asking, and further, without a resolution from the board with a specific ask as to why. I'm confused as to why this legislation is needed or before the body. We've got a lot of other work to do, and I just moved to PBI.
Madam Chair,
Senator,
a substitute motion. If the patron had testimony in Appropriations Committee and they set out what it was that they were attempting to do, and this generates some savings, then I would offer the substitute motion that we report the bill and re-refer to Finance.
moved and seconded that House Bill 1206 be reported and re-referred to Finance. All those in favor, please vote aye. Those opposed, no. Who's got Boy Scout?
Ayes 10, noes 5.
Ayes 10, noes 5.
Thank you.
Thank you,
Madam Chair.
Delegate.
Thank you.
Okay, we have Delegate Wilt, and we have the Bell docket. Okay, Delegate.
Good afternoon. Excuse me, Madam Chair, committee members. Before you is House Bill 833. It creates the Operation Ceasefire Grant Fund.
And it's identical to Senate Bill 592. We have a substitute? Do we have a substitute?
Staff.
No? Okay, then I'm seeing that it's identical to Senate Bill 592
Move to report. And
and re-refer to Finance? Yes, ma'am. Okay. It's been moved and seconded that House Bill 833 be reported and re-referred to Finance. All those in favor, please vote aye. Those opposed, no.
Ayes 15, no 0.
Ayes 15, no 0.
Thank you, Madam Chair, committee members.
Okay, so we have now the Bell docket.
Morrissey docket across the way. I apologize for. Madam Chair, I don't know how much time you have. We have two itty-bitty ones, and then the one we did hear evidence on last time that's not itty-bitty, but you had a previous hearing, and I'm happy to do this however you wish.
Let's do the easy ones first.
Okay. Madam Chair, House Bill 750 is the arrest and summons code of prohibition. It is intended
It's identical to Senate Bill 327.
Supposed to be.
Second.
Okay, does this have to go anywhere, Holden? Okay. Okay, it's been moved and seconded that House Bill 750 be reported. All those in favor, please vote aye. Those opposed, no.
Ayes 15, no 0.
Ayes 15, no 0. That bill is reported. Okay, what do we have next, Delegate Bell?
Madam Chair, House Bill 746, I don't believe there's a Senate patron. It is a small bill.
Okay, let's go with that one.
Okay. Madam Chair, this bill would set up a volunteer fire department training fund. The issue has been, especially with COVID, they've had some issues with trying to get the training done. The enactment clause would require stakeholders groups to meet and to try to determine if there's got to be some better way for them to get the training. It's usually the training for the trainers which is causing the money, so they have to go to another city, pay for the hotel rooms and the rest of it. We tried to get them to do this through just letters and talking to the executive branch officials, and nothing happened over the course of the year. So the House budget includes some money to go into the fund. This bill just creates the fund into which the money would go. And that's the bill.
Are there any questions?
Second.
Okay, it's been moved and seconded that House Bill 746 be reported and re-referred to Senate Finance. All those in support, please vote aye. Those opposed, no.
Ayes 15, no 0.
Ayes 15, no 0. That bill's reported. Okay, what do we got next?
Madam Chair, the last one is the one we had hearings on last week, 734. You all sent me off with marching orders, instructions. I can tell you what we've done. We've talked to stakeholders, have got a substitute. I can do this as quick as you need, but I also don't want anybody. Okay.
It's been moved and seconded that the substitute be adopted. All those in favor, please say aye.
Aye.
Those opposed? Okay, we have the substitute.
All right. Madam Chair.
So what did we do?
Okay, so if you recall, this was a bill that there are protections in the code with regards to disclosure of information, and this bill would increase those protections for, in our view, crime victims. Between you and staff, you identified several things. So line 49 and 50, the substitute You said, what if the family is themselves a suspect? So we added the language elsewhere that said, so long as the family member is not a person of interest or a suspect in the criminal investigation proceeding. That's the first thing. Second, one of your speakers told us that we were far too limited when we said it would be limited to those people who are doing writs of actual innocence. And so lines 52 through 54 now says it'll be available, the records will be available to an attorney representing a petitioner in a petition for writ of actual innocence, habeas corpus, or any other federal or state post-conviction proceeding, which is as broad as we could think to make it. One of the attorneys said, if we do this, we need more time, so we increase the time from 30 days to 90 days. And then it's 90 days from the final determination of the writ, or within 6 months if nothing, if in fact it doesn't happen. On line 60, there's a question to confirm that lawyers can actually use it. They felt the language wasn't sufficient, and so we reworked that. Staff did the work, and they said, we shall not release criminal investigative files or any information contained therein, quote, except as necessary to provide adequate legal representation. And then finally, Madam Chair, all of that was related to post-conviction, but the VTLA contacted us and said, you know, there are civil matters not related to post-conviction. So in Madam Chair's case, she may need information from a case involving Senator Ruff. And so with the VTLA's approval, and the language was, they worked on it through last night, and they approved the language, and it says they can go inspect Senator Ruff's language. Once they find that it's there and have a case, they can just subpoena it or get it through the normal processes. Their fear would be they wouldn't know it was there, wouldn't have a case to file, nothing to get a subpoena with, and so it kind of, you know, there's a chicken and egg issue. Lastly, on line 67, we actually just returned it to existing law. We had something more complicated and took it back to the law as it exists today. Those are the changes that were made in anticipation or comments made by you all or by the speakers. And otherwise, as we've talked about, it's a policy decision. And there were, I want to be very clear, I don't want anybody to vote for this not knowing what is in the current law. In current law, there are protections. I talked with Senator Evan about this. There are prohibitions about the actual photo that depicts the victim or a photo that allows the victim to identify. That's in current law. There are privacy exceptions that mirror some of the language from federal code. It's our position that we think that those are not sufficient, but again, that's a policy decision for you to make. Thank you.
Are there questions?
Madam Chairman, I have a question.
Senator Bell.
Concern was raised to me, so I'm just going to ask you the question. I looked at the bill, tried to figure this out, but I want to make sure I have it right. The definition of immediate family, and then I know an item is at the beginning of the bill, and then in item D, it goes into more definitions of different people who can make requests. If a child whose parent was killed or the parents of a married adult child were to request it, would they be able to get the information? And in particular, the parents of a married adult child, would it only be the spouse? I would think on the child, they could use a guardian if they were a minor, and on the other one, I'm not sure. So I want to see if I'm thinking about this correctly, and would that be a possible problem area?
So it would only be, I'm just thinking this through, it would only be for homicide. Otherwise, it's the victim himself or herself. The other criteria only arise when the victim is dead or a minor. Now, the language we use is immediate family. That comes from the code, and I would defer to staff. My recollection is it's a vertical, parents, spouse, children, and I believe it includes grandparents. Is that right? We didn't want to invent new law, but we were using.
There's a couple different definitions of immediate family, but the standard one that we see in code is that list: the spouse, child, parent, and a grandparent, grandparent.
And it's not. It's if you remember, we had a discussion about what if two people disagree, and we actually erred on the side of if you want it and he doesn't, you get it. It's not a vote. There's not a primacy. It's not like a will.
Yeah, Mr. Chairman, I know there's. I asked the patron, do you think this is something we should address, could address that situation of a parent of an adult child who they would not have that ability? The custodian, I guess, could give them that ability.
I think they would have it.
Parent would have it. They would have it. Okay.
Please let me defer. This is again not where I practice.
Madam Chair, Senator Bell, I wouldn't read it as saying if there is a spouse, that means the adult parents couldn't get it. I think if someone's a member of an immediate family, it's not an either or. It's just going to be if you're a member of the immediate family and the victim is deceased.
Okay, thank you. I appreciate
It's
that.
not a priority. Now, they could all get it, and some could want it, and some could not, and we could have had a different approach, but the thought was any member of the immediate family should be able to get it if they want it.
Thank you.
Other questions? Anyone here in opposition?
If you're in the Zoom room and wish to speak in opposition, please raise your hand now.
Behind you, Delegate Bell.
I'm sorry, let me get out of the way.
Thank you, Madam Chair, members of the committee. Megan Ryan with the Coalition for Open Government. And despite being what I consider a stakeholder, this is the first time that I'm seeing the substitute. Despite having offered many options myself, I have tried to make myself available, and I do not feel like the press or the public's interests have been a part of this discussion. There have been at least 10 different angles and viewpoints that have been shared with you all that I've been copied on in the past week. This creates a new legal cause of action within FOIA. It is based on conflicting interpretations of existing statute, and this is the exact reason that it should go to the FOIA Council for study instead of passage at this time. Thank you.
Thank you.
Amy Perrin-Saggart on behalf of the Virginia Press Association. I will associate my remarks with Megan's. We agree. We think this is something that is really just far too complicated and needs to go to FOIA Council. So thank you.
Thank you. Okay, we have 3 people in opposition on Zoom. If you could, you got 2 minutes.
Lori.
Total.
Lori Goodbody, please unmute and begin your testimony.
Hello, good afternoon. My name is Lori Goodbody. My niece, Molly Miller, lived in Charlottesville and died on New Year's Eve weekend 2017. And I thank you for the opportunity to speak here today for myself and other family members and friends of Molly's, many residing in Virginia, opposing Bill HB 734. I hope and pray that you never lose a young, vibrant family member to tragedy under very suspicious circumstances and then have detectives look you in the face and say, we messed up, followed by years of we can't and won't tell you what that means or how we messed up. I hope and pray that you never hear the words, you'll never get the outcome you want from a FOIA officer. I hope and pray you never experience the
Minute and a half
frustration,
left.
pain, and agony of non-disclosure and hidden facts about the death of a loved one. Why is it okay for police to admit they made mistakes?
There are other speakers. Thank you. Jason Nixon.
Yes, good afternoon. How are you doing today? I oppose this bill. We spent a lot of time last year building this bill up with me and Delegate Hurst. I don't like the fact that you guys are changing things on the fly. One of my good friends, Barry Knight, actually said that on the floor Thursday, said that you don't change things on the fly, you don't create laws on the fly, and you don't change laws on the fly. You need to study this law. It's already been studied once. It's been thoroughly studied. I don't agree with what's going on right now. I don't agree that you're taking things out of context. You're not even considering the fact that if someone was dating someone for 25 years and that their lover can't even find out what happened to their loved one. There's a lot of things you guys got to take into consideration. It's almost discriminating against same-sex marriages because they're not. I mean, if they're not married, then they'd have no rights to anything. So you guys really need to consider this. I mean, I did this for transparency for me and my family because I was owed that. The police didn't tell me nothing. We just recently found out from the Quantico FBI that Kate was on a list, that the guy did have an email draft he hadn't sent to nobody, and Kate's name was on that list. We found it out because of FOIA.
Thank you, Jason.
We need to keep this open, and we need to keep this discussion open. We're not going to let you guys.
Juliet Hatchett.
Hi, I'm Juliet Hatchett. I'm from the Innocence Project at UVA School of Law. We also oppose this bill. The amendments to the statute that were most previously made have had a profound impact on our ability to investigate cases. It has resulted in the exoneration of at least one person this law. There are many cases we have of individuals who served time in prison that they would not have had to serve had this law been in effect at the time. So we strongly oppose this, would ask that it at least go to the FOIA Council. It's a nuanced issue. We need access to not only our own clients' files, but also those of potential alternate perpetrators, other suspects, people providing incentivized testimony. It's a nuanced issue with a lot of different perspectives that need to be considered. Thank you.
Thank you. Are there those here in support?
If you are in the Zoom room and wish to speak in support of this bill, please raise your hand electronically now. Madam Chair, there are no speakers.
Thank you. Delegate Bell, if
Madam
you could
Chair,
wrap up, please.
You had a very lengthy hearing. I did not ask my people to call back in if you'd already heard from them.
Okay.
Madam Chair, before
Senator McPike.
Delegate wraps up, could you address the last speaker's issue, Delegate Bell, and how your substitute treated? Because that was one of the main things to making sure that there's still access where people were pursuing digging into files. Can you address that in the
Right,
substitute,
and
make sure it's
so,
clear?
This is not a repeal of last year's law. This is an amendment, and it allows the changes that were made on behalf of crime victims to remain. And then we initially said also for those pursuing a writ of actual innocence. And then I don't recall if she was the speaker last time, but based on her comments, we then expanded it again to cover every person that staff could think of. But again, petition, a writ of actual innocence, habeas corpus, any other federal or state post-conviction proceeding. But then the VTLA language was also helpful because I think when someone's pursuing something, they may not know if it's going to be a writ of innocence or civil matter, but it does allow lawyers who represent and who can file an affidavit that that's what they're doing. It says they can inspect the records at the location where they're maintained by the public body if they provide a sworn declaration that the attorney has been retained by an individual for purposes of pursuing a civil or criminal action and has good faith basis to believe that the records being requested are material to such action. The thought is that being a lawyer provides a level of oversight and that will protect those records from just being, again, placed on the internet or get out there, so to speak.
Okay, any additional questions? Okay, so we have Delegate Bell's bill before us.
Madam Chair,
Senator
just
Reed.
real quick, in layman's term, Delegate, the folks that just talked about the innocent projects, that's attorneys from UVA. They'd still be able to go help their folks they're working those cases.
We have
as
made
officers of the court.
Listening to what they said last time, we made every effort to think of the various ways that they would be representing a client and need access to the records. And then the VTLA approved the language for people that are not directly approaching it from an innocence post-conviction perspective, but frankly, any other civil or criminal proceeding for which they would need to have access to the records.
Senator Stewart.
Letting them use it down there. Madam Chair, Delegate Bell's done a really good job. We did study this in the FOIA committee, FOIA council. I apologize. But it seems to me he has provided a way where attorneys can get this information to serve clients, find that it is there, and then go through the court system to use it in their case in chief, which I think is a good resolution for that. But at the same time, it does protect victims. And we do want to protect victims as much as we can. We don't want those pictures out on the internet and those people having to relive that. And so I move the bill be reported.
Speaking to the motion, Madam Chair, very briefly.
Hold on. It's been moved and seconded that HB 734 be reported. Further discussion.
Just want to be clear that there are no pictures of the victims that would be on the internet under any circumstance, in my understanding.
The current
Personal
law
identifying.
Current law prohibits the disclosure of photos that depict the victim or that could identify the victim. That's current law, so that does not change. The other videos, photos that are in the record that do not meet some other exception would be provided under current law.
All right. Those in support of the motion, please vote aye. Those opposed, no.
Ayes 9, noes 5, 1 abstention.
Ayes 9, noes 5, 1 abstention. Bill's reported.
If I was your last one, thank you.
All right. What is his? 775. Okay, so we can't take that. We gotta go. So we only have one bill left, but we gotta go. So where is he?